everyone. Thank you so much for joining our most recent webinar, providing insights to employers on the latest in drug testing. This webinar is brought to you by Orange Tree Employment Screening and will be presented by Bill Current. Bill is the president and founder of the Current Consulting Group and a 30-year veteran in the drug testing industry. Bill is also the author of 10 books on substance abuse related issues and a regular presenter at conferences, seminars, workshops, and webinars like the one you are on today. Bill is widely considered to be one of the leading experts on drug testing and in the drug testing industry. We are so excited to share his knowledge with you today. Just a bit of housekeeping before we begin. If you have any questions, you can ask them in the chat window. At the end of the presentation, Bill will be available afterwards to help provide answers to those questions. And then just another note, the presentation and a recording of the webinar will also be available afterwards as well. So thank you all for joining us, and take it away, Bill.
Well, thank you very much. And first and foremost, I want to just commend Orange Tree for hosting their webinar series. We've worked with Orange Tree before on webinars to do a great job, and it's so important to provide this information because the knowledge that is necessary to maintain a drug-free workplace program in today's environment, with the legalization of marijuana, with multiple testing modes available, et cetera, there's just a lot of knowledge that you need to be able to do this. So kudos to Orange Tree for this webinar today and for all the webinars that they do and have planned this year. We're going to talk about impairment versus under the influence in sort of the broad context. I want to encourage you to put your questions into the chat section so that we can address those towards the end. I've got a lot of slides. If I get towards the end and it seems like I'm rushing, it's only because I want to allow time for the Q&A at the end. If there are any questions that you ask that I don't really know the answer to, what we'll do is we'll research it for you, and then Orange Tree will send out the responses so that you get all your questions answered. So we're going to go through this agenda, and again, it's a little bit diverse. We're going to talk about under the influence and impairment and how to define them and how to treat them from a policy perspective. But I sort of want to set the stage for that so that we understand why it's important to understand the difference between those two terms. I've got a slide coming up a little bit later. I'm going to sort of steal the thunder from it right now, which is to say that under the influence and impairment are not the same thing, and they get used interchangeably and usually erroneously. So part of the agenda, part of the objective today is to clarify what under the influence means versus impairment, and specifically within the context of a drug-free workplace program versus on the road. I'll explain what it means in terms of, driving under the influence or driving while impaired, and then make a connection to the workplace. But we'll talk specifically from a policy perspective how these two terms should be used properly in the workplace. So let's start with some drug-free workplace information. So in a 2018 study, it was actually a survey by the National Safety Council, these were the industries that had the largest number of workplace injuries. So it started with the service industry, including firefighters and police, so first responders, transportation and shipping, manufacturing, production, installation, maintenance, and repair, and then construction. Now, I want to focus on this just for a second because I know we have people on the call today who are from these industries, or maybe you interact with vendors from these industries. If you were to look at a study that comes out every year from the Substance Abuse and Mental Health Services Administration, from SAMHSA, they do a study every year on the magnitude of the drug problem. And it's called the National Survey on Drug Use and Health. Used to be called the National Household Survey. You may remember it or think of it in those terms, but it's the National Survey on Drug Use and Health. And it will give you data. It's a survey of tens of thousands of people, and it'll give you data on the magnitude of the drug problem in different areas of society, including the workplace. And if you have to really dig to find it, but you can find a breakdown by employment, whether it's full-time, part-time, or unemployed, and you can typically find information where it breaks it down by industry. And so the industries with the highest rate of drug abuse are typically construction, over there on the far right, would move over to the far left, manufacturing, and then to some extent these other industries. Transportation, not so much. Why? Because for many years now, the transportation industry has required drug testing. The U.S. Department of Transportation has required drug testing of safety-sensitive workers in the transportation industry. So you have truck drivers, for example, you have people in the transit industry, in railroad, et cetera, aviation, of course, that have been subject to drug testing for years and years and years. And so typically, the rate of drug abuse in the transportation industry is lower. I only point that out because as we start talking about drug-free workplace and drug testing and impairment versus under the influence, of course, we want our transportation workers, the people who are piloting airplanes or driving semis on the freeway, to be drug-free. And sometimes the opponents of drug testing look at this data and say, well, why are we doing so much drug testing under the U.S. Department of Transportation regulations when the drug abuse levels in the transportation industry are so low? And my response to that is, it's low because we've been doing drug testing there for 30 years. There's a culture of prohibiting drug abuse and enforcing that from a policy perspective with drug testing. Now, keep in mind, as we venture into this subject, we'll get into a lot of percentages from different studies and reports, and it's all very interesting, but keep in mind, we live in the day and age of legal marijuana. I've got some slides coming up on that. How many states have marijuana legalization, et cetera, et cetera. Understand this, that no matter what state you're in, no matter what your marijuana law says in your state, Nevada, Illinois, New York City, which are very restrictive toward drug testing for pre-employment and marijuana users. But the U.S. Department of Transportation drug and alcohol testing regulations are not subject to those state laws. In other words, the federal regulations trump the state laws. And so if you're in the transportation industry, if you are a covered employer under, say, the Federal Motor Carrier Safety Administration regulations, you must continue to drug test for marijuana, both from a pre-employment perspective as well as post-hire. So as you look at this particular slide, we see that the number of injuries is largest among the service industry, the number of injuries, and transportation, manufacturing, installation, construction, but the highest rates of drug abuse are typically construction and manufacturing and service, not as much with transportation. But again, I give the credit to the drug testing that's been going on there for 30 years. Now, we all know the different ways in which drug abuse can manifest itself in the workplace in terms of job performance, accidents, just showing up for work, etc. These are in part some of the things that all supervisors must understand. So if you have a drug-free workplace program that includes a reasonable suspicion drug testing program, then you want your supervisors to know to look for these signs and symptoms of substance abuse, because it may, in some instances, trigger a reasonable suspicion or for-cause drug test. And those are the very things that are going to be included in a typical supervisor training program under the DOT regulations, or outside of that as well. And you can talk to your Orange Tree reps about, getting access to that kind of training. There's some statistics that I included some years ago, not a lot of years ago, but some years ago in a book I wrote called Why Drug Testing. And so in the book, you find the sources of all of this information because they come from different studies and different reports. So 38 to 50% of all workers' compensation claims related to substance abuse in the workplace. 3 to 5 times more likely to file a workers' compensation claim if you're a drug user versus a non-drug user. Substance abusers are incur 300% higher medical costs. They're 2.5 times more likely to be absent from work 8 days or more a year, and they're 33% less productive. Now, let me focus on that just for a second. You think to yourself, well, what's that got to do with safety in the workplace and being concerned about impairment versus under the influence? Think about this. A a worker who is less productive is often somebody who's absent more times than other workers, among other things, right? They're just less engaged in the job, less present in their mind. And so they're more likely to be involved in accidents as well. But they're also putting a particular strain on the rest of your workforce, which sometimes can lead to sort of mental and physical fatigue and exhaustion, too many or too few people trying to do too much of the work, and that can lead to more accidents as well. So when we talk about substance abusers being a third less productive than their coworkers, it has a direct impact on workplace safety. And that's where the connection to under the influence and impairment comes into place. These are some statistics that I also found very interesting that I've included in my book. Incidentally, Why Drug Testing, I'll just put in a little plug. It's a book that we're getting ready to republish with updated statistics in it. But some of these statistics are not going to really change from new studies that have been done. 37% of substance abusing workers with small companies worked for 3 or more employers in the past year. 53% worked for 2 or more employers in the past year. And then the second bullet, 28% of substance abusing workers with large companies, 500 or more employees, worked for 3 or more employers in the past year. Before I get to that last bullet, let me just point out with those first 2 bullets that this is important because it costs money to hire people. It costs money to train people. It costs money to retain workers. And so if you're hiring substance abusers, there's a greater chance that that employee is going to quit or get fired or move on for some reason, and you're incurring the cost over and over and over again because of substance abuse. Now look at the last bullet. 7% of current drug users with small companies were fired from their job in the past year, 9% were laid off, and nearly 30% voluntarily left. Think about that. That every time that happens, it's costing your company money because it costs money to hire people and to train them and to retain them. The cost of the problem can be viewed in a lot of different ways. So there's some big numbers on here, 74 billion, 200 billion. I like the third and the fourth bullets the most. In Wisconsin, they did a study, and this goes back to 1989, but I haven't found one that's more clear than this. And this is the kind of study where the result doesn't change from year to year to year, not that much, right? So the state of Wisconsin estimated, they did a study, and they estimated, and this was Wisconsin workers, okay, Wisconsin government workers. So it wasn't even in the private sector. Wisconsin estimated that the expenses and losses associated with substance abuse equaled 25% of the salary of affected employees. So is it 26%, 27%, 24%, 23% today? It doesn't really matter. It's about a quarter of the affected employee's salary. That's a little bit closer to home, right, than the 74 billion and the 200 billion. Those are important numbers, of course, but what does it cost your company? Or if you're in the drug testing business, how do you talk about this with your clients? So let's go to the fourth bullet. The US Navy had a very serious problem with drug abuse coming out of the 70s and into the 80s. Some of you may recall that in 1981, there was a tragic plane crash aboard the USS Nimitz, an aircraft carrier, where 14 people were killed, 50-something people were injured, millions and millions of dollars in damages, 7 planes were damaged. The Navy did a study to determine just how big their problem was. And I'm not going to go into those, so that's a different presentation, right? But they determined that the cost of a substance abuser per year was somewhere between $6,000 and $7,000 using those numbers that you see on the screen right there. Okay, so my headset went on mute and I'm talking, and Jessica, my assistant, pointed out that I was still on mute. But so let me just repeat this to make sure that I said it and you heard it, which is the Navy did the study and they determined that each substance abuser costs between $6,000 and $7,000 a year as you look at that fourth bullet. Now we can start to relate that to our workplace today, here and now, because $200 billion is an interesting number, but I don't know how that really affects my company. So let's go to the next slide. If you have 200 employees and 17% of your workforce are drug users, and 17% is the percentage of the population of adults excuse me, who admit to being regular drug users. The government defines a regular drug user as someone who admits to using an illicit drug at least once in the last 30 days. So 17% is right around the national average. And if each one of them is costing $7,000, remember, we're taking the high end of this range from the study conducted by the US Navy, then substance abuse is costing your company $238,000 a year. Okay, well, if you're a small business with 200 employees, that's a lot of money. If you're a big business with 2,000 employees or 20,000 employees, it's still a lot of money. It's still money that you don't want to lose. Now, go back to this Navy study for just a moment. One of the things that the Navy did not include in its study was what you and I in the private sector would be very concerned about, which are accidents in the workplace and workers' compensation costs, workers' compensation claims. That's not even factored into the Navy study. In the private sector, that's a big cost factor. So this $7,000 a year that we're using for this calculation is probably $10,000 or $15,000 in the private sector. So you could add some percentage of that 238,000 to the total, and you're probably somewhere closer to $300,000 or $350,000. And that's what it really means to you as a small business owner. So let's talk about under the influence versus impairment. These are the common signs and symptoms of substance abuse or possible substance abuse in the workplace that can either be categorized as under the influence or impairment. We don't have to go through each one of these, but you know what they are, right? Employees who have the look may be under the influence or may be impaired while at work. There's certainly an impact from illicit drug use on the mental and emotional capacity of the worker. Now go down about 5 bullets there on that column, you see hyper and hypoactivity. So hyperactivity is that they're just sort of full of energy, and hypoactivity would be the opposite, where they're sort of lethargic by comparison, right? And you see sometimes a shift in the behavior or the performance of an individual in the workplace, where they're just sort of too active, too hyper, or just sort of not their normal self. And so these are some of the signs and symptoms of somebody who could possibly be under the influence or impaired in the workplace. But what's the difference between the two? Okay, now look at the first bullet. If you have one drink of alcohol, depending on the individual, but you're probably could be considered under the influence because it's a alcohol is a psychoactive drug. It's intended to have an effect on your mental capacity. It doesn't mean that you're impaired though. It just means that you have alcohol in your system and that alcohol is influencing your behavior. Impairment occurs when you can no longer function normally because of the alcohol or the drugs that are in your system. Now, we always hear, this statement made that, oh, he can really hold his liquor, or she can really hold her liquor. That's not what we're talking about necessarily, because no matter how well somebody can quote unquote hold their liquor, if they're drinking alcohol, they're under the influence to one extent or another. They may not, however, be impaired, or they may not be to the point where they can no longer function normally. So what does it mean to be impaired? First, the second bullet there, the state of being diminished, weakened, or damaged, especially mentally or physically. So let's look at it from the point of driving a car. A person who is actually impaired, and I'm reading this because I want to point out these words, impaired by alcohol, but alcohol can be convicted of impaired driving whether or not the person's blood alcohol content was over the legal limit. So you're driving a car, your driving or your behavior as a driver gives cause to be pulled over. Now, driving under the influence, or DWI, driving while impaired, can be proven by a cutoff level of a test or the signs of impairment according to the officer, or it can be the positive test result from a breath or a blood test. However, and so here we're talking about, on the road, driving a vehicle, being pulled over, and then being subject to some type of an impairment testing process, okay? May include a breath test, okay? But in the workplace, and as the employer, you're not going to be out there following your employees around while they're driving trucks for you or driving cars to appointments and stuff like that. In the workplace, we want to treat under the influence and impairment differently. The two terms, as I mentioned earlier, are often and erroneously used interchangeably as if they mean the same thing, but they're two different terms or words that mean very, very different things. Impaired or impairment is technically a legal term defined by law, while under the influence is typically a policy term defined by the employer. Let me give you an example. So not in every state, but in almost every state, 0.08 blood alcohol content level is considered, or higher, is considered legally impaired for driving purposes. In other words, that's the federal standard, 0.08. I think it's 0.05 in Utah. But for alcohol, 0.08 or higher is legally considered impaired while driving. So it's a legal term, a legal definition. If you're 0.08 or higher, you're legally considered impaired. Not under the influence, but impaired while driving. In your company policy, though, we want to avoid using the word impaired because technically we can't prove that somebody's impaired because of drugs or alcohol. Because if you look at the last bullet, for 30-something years now, legal and scientific experts have determined that a drug test does not necessarily prove impairment. It doesn't prove that somebody in that moment was impaired. They may have been behaving in a way that seemed by every outward manifestation to be someone who's impaired, but the drug test itself doesn't prove that the person was impaired. So if in your policy you're telling or you're prohibiting individuals from being at work impaired, you're faced with the task of being able to prove that. And the drug test result doesn't prove it from a legal or from a scientific standpoint, because you can't pinpoint exactly when the drug was used, how much of the drug was used, and with this person, was that impairment or not impairment? In other words, can that person really hold their marijuana, so to speak, or not? So in your policy, you want to lean toward the term under the influence, and you want to define under the influence as, among other things, producing a positive drug test result. If you do it that way, then you're not accusing anybody of being impaired, which leaves open the possibility of challenging your assessment that the person's impaired. And you're able to simply say, from a policy standpoint, we don't allow our workers to be at work while under the influence. And we define under the influence as A, B, C, D, E, and a positive drug test result. Now, you may not take action, any type of adverse employment action based on that test result, but it may be one of several factors that demonstrate and prove beyond any doubt that the individual violated your company policy, because they're not allowed to test positive. And at the cutoff levels that we commonly use in this industry for the various drugs, you can say that that proves the person was under the influence, meaning they had the drug in their system at the time that they were tested, and that's the violation. You're not accusing somebody of being impaired. Now, sometimes employers use those two terms, impaired and under the influence, as if they mean the same thing. But more dangerously than that, lawmakers use the two terms as if they mean the same thing. And so sometimes you're going to be reading your Illinois marijuana law, and you're going to see those terms in there, impair or impairment, those words, and you're going to wonder, well, what's that mean for me as an employer? Well, you don't want to use those terms in your company policy. You want to stick more to under the influence. Now, doesn't mean everything I'm saying here, don't take it as legal advice, because it doesn't mean that an employee or a job applicant isn't going to sue you because you didn't give them a job, or you terminated them, or you required them to go into some type of an EAP treatment program because they tested positive. They may still sue you, but your policy is going to be very clear. We didn't accuse this individual of being impaired. We simply prohibited them from being under the influence, and we defined very clearly for that person, long before they tested positive, that under the influence means, among other things, a positive drug test result. So let's pause here for a moment. Think about the questions that you want to ask on that, because when I share that, usually in a conference or a webinar, there are a lot of questions on that topic. So feel free to put your questions into the chat section so that we can talk about that in more detail. And we're on a really good pace right now, so we're gonna have plenty of time towards the end for questions. Put your questions in there, and we'll come back and talk about impairment versus under the influence and how to address it in your policy based on your questions. Let's talk about drugs of abuse for a moment, though. You can't talk about the whole issue of impairment versus under the influence nowadays without spending some time on the marijuana issue. The map you see in front of you shows the states that have passed recreational marijuana laws and the states that have passed medical marijuana laws. Keep in mind that some of the orange states are also really blue states as well, because every state that has a recreational marijuana law also has a medical marijuana law, or they started out with a medical marijuana law, and then in time, and sometimes it didn't take much time, they also passed recreational marijuana. As I say that, I want you to know that I know that marijuana is illegal from the federal government perspective. It's still considered a Schedule I controlled substance, which means it cannot be prescribed. That's part of the definition of a drug that falls under Schedule I of the Controlled Substances Act. It's a drug that cannot be prescribed. There are no known proven medical benefits or uses for that drug. Therefore, it's Scheduled I, it cannot be prescribed. That's going to come in handy in a couple of slides. But as we look at this map in front of us, these are the states that have legalized marijuana, either recreationally or for medicinal purposes. The states in white haven't done so yet, but some of those states have actually moved to decriminalize marijuana, essentially making it not illegal to possess marijuana or to have marijuana plants in your house, etc. The difference is some of these states are very clear in how they legalize marijuana. It can be smoked, it can't be smoked, etc., etc. But why would you have a recreational marijuana, or excuse me, why would you have a medical marijuana law if you're going to legalize it for recreational use? And as you read typical examples of medical marijuana laws and recreational marijuana laws, you see a big difference, and it often has to do with the workplace. Let me explain. In many medical marijuana states, the law specifically prohibits you as an employer from discriminating against somebody who's using medical marijuana. In other words, they're a registered marijuana user in your state for medicinal purposes. Recreational marijuana laws typically don't touch on that at all. Now, there is a movement now, and you saw it in Illinois last year leading into a law that went into effect at the beginning of this year. You see it in Nevada and some other places where it's you're seeing language in the recreational marijuana laws that protect any user of marijuana because marijuana is quote unquote legal in that state. So whereas before we were seeing medical marijuana laws passed, some allowing smoking, some only allowing like CBD oils and things of that nature, which of course has THC in it, protecting or the medical marijuana user or prohibiting the employer from discriminating against somebody solely based on the fact that they were a registered medical marijuana user. Now you're starting to see a little bit of similar type of language in the orange states, the recreational marijuana states. There are 11 states that have actually legalized marijuana for recreational use. This is concerning for a lot of different ways, right? So in the beginning, as the marijuana legalization movement came out of the 80s into the 90s, into the 2000s, one of the arguments that the pro-marijuana people made was that legalizing marijuana is not really going to lead to an increase in the use of marijuana. And it's certainly not going to impact the workplace because we have drug testing and drug-free workplace programs in place all over the country. Now, of course, they're attacking the workplace and drug testing programs. But look at that first bullet. 20% of young workers, we're talking about workers under the age of 30, admit to using marijuana on the job. So most of these pro-marijuana laws prohibit you as an employer from discriminating against legal users of marijuana. Okay, in most cases, we're talking about medicinal marijuana. But in those very same laws, it prohibits individuals from being at work under the influence of marijuana, or in some cases, they use the term impaired or impairment, the words, or from using marijuana while on the job. And yet, we've got reports that show that 20% of young workers admit to using marijuana on the job. Under the influence or impaired? So let's look at this for a second. Marijuana potency has dramatically increased over the past 30 years. I did a little research on this and found that the THC content, now THC, tetrahydrocannabinol, is the psychoactive ingredient in marijuana. It's the thing that makes people feel high. The THC level, typically in marijuana from the 1960s, right? We talk about the drug revolution of the 1960s. The THC level in 1960s marijuana was about 1% to 2%. Never would have even made a Cheech and Chong movie back in those days at 1% and 2%, right? Because if you ever saw some of those, if you grew up in the 70s, they were always talking about certain strains of marijuana, and it wasn't 1% to 2% that they were talking about, but that was the average. In 2014, the average was 6.1% THC content in typical marijuana. In Colorado, one of the very first states to legalize recreational use of marijuana, right now it's 18.7%. So we're talking about a significantly more potent version of marijuana today than back when I grew up in the 1970s. And somebody using marijuana, a lot depends on how much they use, etc. But a single use of marijuana can result in somebody being impaired, although I'm going to prefer the term under the influence, but in the report they use the word impaired, for up to 24 hours after use. And this should be of concern to you if you have workers in your workplace who are driving vehicles, operating heavy equipment, or doing some other type of safety sensitive function. Keeping in mind that first bullet, 20% of young workers admit to using marijuana while on the job. Now, prescription drug abuse, obviously a big problem in our country. So prescription drug abuse, okay? And this is just a chart that shows sort of the rate of prescribing medications by state. And it would take a 30-minute explanation here, but you can see that some states, according to the colors, there's a greater tendency to prescribe medications in those states versus the other states. But every year, the current consulting group, my company, for the last 22 years, we have conducted a survey of drug testing, or companies in the drug testing industry, and we've also conducted a survey of employers. And I point that out because I'm talking about the latter here, the 2019 employer survey, which we conducted. We asked the question about whether you as an employer were concerned about safety in the workplace due to prescription drug use, drug abuse. 62% of our respondents, out of a total response, I think last year was about 900 people responded to the survey. 62% said they were concerned, and 28% said they were at least slightly concerned. That's 90% of our respondents saying that they were concerned from a safety perspective. Decreased quality of candidates or employees, people applying for the job, 46% concerned, 39% slightly concerned, 85% total. And then the increased cost in the workplace from prescription drug abuse, 51% concerned, 34% slightly concerned. You can see again, the vast majority of employers expressing concern about the rate of prescription drug abuse and how it's affecting their workplace. There has been, over the last 10 years, a pretty dramatic increase in the use of controlled substance medications. And so a lot of medications, of course, are one of the various schedules in the Controlled Substances Act, but they're not Schedule 1. They're not like marijuana, for example, where there's no medical benefit for the use of that drug and it's illegal to prescribe it. These are drugs that have been proven to have some type of medical benefit and can be prescribed. And so, as you see in the second bullet, a lot of them fall into the opiate category, and there's been a significant increase there in substance abuse, even to the point where under the SAMHSA guidelines, 49 CFR Part 40, and that affects the DOT regulations, we've expanded the drug testing panel. They still consider it a 5-panel test, but we're testing for additional types of opioids. Hydromorphone, for example, hydrocodone, etc., fall under the category of opioid testing. So it still is a 5-panel drug test, but it's been expanded within those categories of drugs. And they can be quite impairing. I mean, an individual who is under certain the use of certain types of medications can literally be impaired. They're not simply under the influence, but they're impaired while on the job. So we want to make sure that we're aware of those things and we address it in our company policies. And now I am starting to pace myself a little bit faster, so to make sure we allow time for the Q&A. Alcohol use and abuse, still the #1 substance of abuse in the United States by far. If you compare alcohol abuse with all illicit drugs and legal drugs combined, alcohol abuse and use is still the highest. It has the greatest impact on deaths in the United States compared to other drugs, and it has a direct impact on the workplace as well. Now, let me pause here for a second because I don't have a slide on it, but as employers, you do have the right, under certain circumstances or situations in the workplace, to require an employee to submit to an alcohol screen. And those can be conducted with instant result saliva tests in the workplace, or with breath. Of course, that's the most common method. Under the DOT regulations, you have the choice of breath or saliva. But the point I was getting at is that there is sometimes a misconception. We write a lot of drug testing policies at the Current Consulting Group. That's our core business. And we often hear from employers that they're under the impression that they cannot test for alcohol. You can test for alcohol, especially in a reasonable suspicion, for cause, or post-accident situation. Under the DOT regulations, you must test for alcohol under those circumstances. You want to make sure that you're treating alcohol positives differently, perhaps, than drug test positives, because the laws affect those two categories differently. Alcohol abusers or alcoholics are a protected class under the ADA, the Americans with Disabilities Act, whereas current drug users, and a positive drug test is evidence of somebody being a current illicit drug user, they're not necessarily protected under the ADA. Depends on the circumstances, but in most cases they're not. You can conduct alcohol testing in the workplace. You may be restricted outside of the DOT regulations by a state law, but in most cases you can still conduct post-accident and reasonable suspicion / for-cause alcohol testing. And for good reason, right? And we won't go into all the details from this slide right here, but there are a lot of ways in which alcohol abuse impacts the workplace in terms of productivity, the cost of maintaining a healthcare program for your employees, et cetera, et cetera, et cetera. And if you have workers who are operating heavy machinery or driving motor vehicles, even trucks, et cetera, then it becomes even a greater concern for you as an employer. And it manifests itself in many of the same ways. Abuse can cause major issues in the workplace, and you see the various bullet points here, the different ways. But we could go back to the slide that we had several slides back where we had the double column showing under the influence versus impairment, and those would be the same things that would come up for alcohol abuse in the workplace. What you're doing with your supervisors is training them on how to spot the signs and symptoms of substance abuse, including alcohol use in the workplace, or employees who are under the influence of alcohol in the workplace. Not asking them to be, drug experts or treatment experts or anything related to that. You're simply training them in how to do their jobs well, which is to essentially observe and judge the work performance of your employees. And sometimes that's going to lead to a drug test when certain signs and symptoms are present. Let me explain this real quickly, because this is important. If you go back to that study I referred to, the National Study on Drug Use and Health, or National Survey on Drug Use and Health from SAMHSA, they define a binge drinker as a man who has had 5 drinks on at least one occasion in the last 30 days and 4 drinks at least one occasion in the last 30 days for women. Heavy alcohol use is binge drinking on 5 or more occasions in the past 30 days. The distinction there, right, is somebody who admits to having 5 or more drinks at least once in the last 30 days, and another person who admits to having 5 or more drinks on more than 5 days in the last 30 days, or 4 more than 5 occasions in the last 30 days. Somebody who's drinking a lot on a regular basis, at least once or twice a week. 139.8 million Americans reported current use of alcohol, meaning they used alcohol at least once in the last year. 67.1 million reported binge drinking, and 16.6 million admitted to heavy alcohol use in the past month. These are all increased numbers compared to just about 4 years ago, 5 years ago in 2016. It just shows that while we're being vigilant about drugs in the workplace and about marijuana in the workplace in particular, we can't take our eye off the ball when it comes to alcohol abuse in the workplace, because it's still a pretty significant problem. So let's talk about the challenge of use versus abuse. So people, if you look at the first bullet, many people can use legally prescribed or obtained drugs without crossing the line into abuse and addiction. That includes alcohol, right? Because it's a drug that has a psychoactive impact on the user, but it's legal. And there's a fine line between, abuse and addiction. As it affects the workplace, though, it becomes more and more clear over the course of time as somebody misses work frequently, they're late for work on a regular basis, their job performance starts to suffer, and then they neglect other responsibilities in their lives that affects their ability to do their job in the workplace. And so that can be somebody who's using prescription drugs the wrong way, who's becoming addicted to those prescription drugs, who's perhaps even obtaining prescription drugs illegally, as well as alcohol abusers. Okay, take a quick look at the slide. What is abuse? Increased risk of problems, inability to control use, et cetera, et cetera. I'll only pause here for a moment to say that sometimes when somebody does cross the line and they get into a very serious problem with abusing alcohol or prescription medications, it's really something beyond what you can do in the workplace to help them. They really need to be referred to a professional, to an employee assistance program. You may be in a state that requires you to have an employee assistance program in order to do drug testing. In many cases, the state will at a minimum require you to provide referral information for that individual so that they can seek help somewhere in the community. And oftentimes some of those services are available at no or very low costs. Okay, I want to make sure I don't skip this. Testing methods in the workplace and how they affect reasonable suspicion post-accident vis-a-vis impairment and under the influence. So we have urine testing, we have point of care testing with urine, hair testing, lab-based oral fluid testing, and then point of care testing with oral fluid. The difference here is that urine testing, hair testing, and lab-based oral fluid testing are tests that take place in a laboratory. You collect the sample, you send it to a laboratory, and it's analyzed in the laboratory. A point of care or point of collection POCT urine test or oral fluid test is a product where you can get an instant result. It's going to tell you a yes or no answer typically, whether there are drugs above a certain cutoff level in that urine sample or in that oral fluid sample. And then you would typically, depending on the state laws that apply to you, we typically would send that sample or a split of that sample to a laboratory to have it confirmed. So in the laboratory, you would typically send a urine sample, it would be analyzed, an initial screen. If it pops positive for, say, marijuana, for THC, then it's going to go through a different second, more sophisticated testing process and be confirmed. And then if it's confirmed positive for that THC, then it's going to be verified by an MRO. With POCT urine or oral fluid testing, you're getting an instant result. So you're knowing right away whether there's drugs in that individual's urine or oral fluid, and then you make the choice to send it to a laboratory for confirmation or verification ultimately by an MRO. Why you test determines, when you're going to test, who you're going to test, and how you're going to test. So you see on the right the different circumstances in the workplace that might trigger a drug test, and you're picking a drug test method that aligns with your reasons for testing. So for example, if you're doing for cause or even post-accident, but for cause reasonable suspicion testing, that's because you suspect the individual's using drugs or they're under the influence of drugs right now. So you're going to want to use a testing method like oral fluid testing, which is able to detect recent use more clearly than urine testing and certainly hair testing. When you look at the cutoff levels for those different testing methods, and let me see, I don't have that that diagram here, but there's a difference in the cutoff levels for urine versus hair versus oral fluid. So with oral fluid testing, your oral fluid sort of mimics blood in terms of the timetable in which a drug is detectable in that sample. And so with oral fluid, you're detecting the parent drug, the drug itself. You're not waiting for the body to break it down into a metabolite of the drug. It's the parent drug itself is detectable, which means that with oral fluid testing, whether it's instant or lab-based, you're going to be able to detect the drugs in that person's system almost immediately after they use the drug. With urine testing, we're looking for a metabolite of the drug typically, and so there's a process of some hours that has to pass before the body breaks it down metabolically into that metabolite that you're going to be able to detect in the urine. With hair testing, drugs are typically not detectable for about 5 to 7 days after usage. Now, if it's a regular drug user, of course, it's going to be in their hair, but it'd be detectable in the hair. But for wanting to know if the person used the drugs recently, then you're probably, for cause or post-accident in particular, you're going to probably want to use oral fluid testing. If you're looking at random, you certainly could use oral fluid testing, right? But you may be more comfortable with urine testing because it's going to give you a broader window of detection. With urine testing at the cutoff levels that we use today, we're looking at a window of detection of 3 to 4 days typically. But with oral fluid, we're looking at a shorter window of detection. It varies by the drug, okay, and the cutoff levels that are being used. But it's typically a shorter window of detection. In the past, some people kind of considered that shorter window of detection to be sort of a drawback or disadvantage to oral fluid testing. But in the age of legal marijuana, when there are marijuana laws that put some limitations on drug testing and how much of that person's lifestyle you can know from a drug test, that shorter window of detection becomes quite attractive now. It becomes very appealing because we're still drug testing, we're still protecting the safety and the integrity of our workplace, but we're only looking at a window of detection of a day or two with oral fluid testing. And we're also able to detect recent use with oral fluid testing because we're detecting the parent drug and not a metabolite of the parent drug. And then it depends on the drugs that you're testing for. The typical 5-panel drug test, which is marijuana, cocaine, opiates, heroin, etc., amphetamines, and PCP, or extended panels. Typically, a 9-panel drug test is very common, very popular today. That includes some additional substances, and it varies by the employer's program. Or you may be looking at a professional panel, which includes, the drugs that professional athletes are typically tested for. That we wouldn't test for typically in the workplace. Now, we talked about this. I'm not going to spend a lot of time on it now because I definitely want to cut off at 10 of the top of the hour to allow time for questions. But you address under the influence and impairment separately. You deal with them separately from a company policy perspective, and you don't talk about impairment in the policy in terms of claiming that you can prove that somebody's impaired with a drug test. This is particularly important in marijuana-friendly, marijuana-legal states. You want to make sure that you're very careful about that. Now, the National Safety Council did a survey of employers in 2017, not that many years ago, And this is a very interesting slide because it shows the different ways in which the respondents to the survey said that their policies were lacking. And I'm only going to talk about the top one, which employee use of medical marijuana. 45% said that their policy covered that issue. 16% not really sure. 39% were pretty sure it did not cover medical marijuana. Every drug testing policy today should have a marijuana section in it. If you're in multiple states with multiple marijuana laws that are different from state to state, you need addendums to your policy that cover each of those different state laws to make sure that you're in complete compliance state by state by state. And let me just kind of forward past these to allow time. I'll come back to some of these if we have time without the questions, but these are all policy considerations. We'll share these slides with you so that you can see what these slides said about the issue of impairment and under the influence from a policy perspective. But this last slide shows that you can address the issue in your policy, but then you want to make sure that you're training your supervisors to understand specifically what the policy says on this subject of impairment versus under the influence, and how you're prohibiting people from being at work under the influence, which you're defining as, among other things, a positive drug test result, and then articulating what the consequences will be when somebody does test positive. You may have some restrictions that apply in the states that you're in, but drug testing is legal and permitted in all 50 states. And how you treat a positive drug test result is not often covered in a state's drug testing law, but there's case law typically in virtually every state that sort of governs that subject. And so you want to make sure you understand the laws that apply to you and the case law that applies to you on a state-by-state basis, and then have addendums to your policy if you're in multiple states to make sure you're in complete compliance. So, talked about a lot of things. I know I went fast towards the end there. Let's turn it over to questions and hopefully answers so that we can make sure you walk away today with the information that you want.
Okay, well, thank you, Bill. That was very interesting, very helpful, and I think also highlighting that it's very confusing for employers. So thank you for your knowledge on helping to clear that up. We do have some questions, and just a reminder that if you could put them in the questions section, we will definitely ask them of Bill. The first one that we received came from Steve. It looks like he's in the healthcare industry. He says, are there any tests similar to an alcohol breathalyzer that can determine the amount of THC in a person's system, and how much is, quote, too much?
Well, how much is too much THC in the system?
Yes, I believe that's the question. Yep.
Okay. Well, so I'm going to answer the question first by talking about the state laws that apply. So I'll just take 30 seconds to explain this. So you have state laws that are very specific on the drug testing method that you can use for any drugs in the workplace. So THC, let's take that as an example because that was the question. So can I test with oral fluid in this state or that state? Can I use an instant oral fluid testing device versus a lab-based oral fluid testing device? Or urine testing, hair testing, etc. And I'll just say at the outset, urine testing is permitted in all 50 states, lab-based. There are some restrictions on some types of instant or POCT urine testing, but urine testing is permitted in every state. Oral fluid testing, when we're talking about lab-based oral fluid testing, it is currently permitted in all, or well, I shouldn't say all states, in 47 of 50 states. Maine, Vermont, and Hawaii have restrictions in place on lab-based oral fluid testing, but it's permitted virtually everywhere. And just as a side note to this, many of you are probably aware that last October, the federal government finally published regulations for lab-based oral fluid testing, which will allow oral fluid testing, lab-based oral fluid testing, among federal agencies. So federal agencies testing their own employees can now choose lab-based oral fluid testing as an alternative to urine testing or in combination with urine testing, maybe merging the two together like we talked about earlier. That doesn't apply to the private sector yet. It doesn't apply to DOT. The Department of Transportation still mulling over when and if they want to put these regulations out there for DOT use for compliance in the DOT regulations. But the sort of the it sounds like I'm punting a little bit on the issue, but it depends a lot on the state that you're in and what drug testing methods are permitted in that state and what the process will be. Now, most states, many states that have drug testing laws punt on this issue of procedures and typically defer to the federal government's drug and alcohol testing guidelines, the 49 CFR Part 40. They may not say 49 CFR Part 40. They may refer to the DOT regulations, or they may even use antiquated acronyms like NIDA or something like that, but they're talking about 49 CFR Part 40. So going forward with these new lab-based oral fluid testing regulations, which are now part of 49 CFR Part 40, you can see where these states would then allow oral fluid testing to be conducted or require oral fluid testing to be conducted in accordance with those regulations. But it hasn't gone into effect for the private sector yet. There's about a 12 to 18 month implementation period to give laboratories time to become certified, to give manufacturers time to get their oral fluid collection devices FDA cleared, et cetera. But in the next year or less, probably not less, as we were talking about earlier with the federal government, everything takes a little bit longer than today. But let's say in the next year and a half, you should see those regulations being out there used among the private sector outside of, say, federal mandated programs. Now, I think I forgot part of the question, Suzanne. There was a little bit that you talked about comparing it to, was it to breath alcohol testing? Did I hear that right?
Yes, to a breathalyzer.
Oh, okay, good. Well, there's no products right now that are commercially available, but there are two companies that I'm aware of, one in Canada and one in here in the USA, that are developing breath testing devices for THC. That's a pretty exciting development. We'll see how it goes between these two companies and maybe others getting into the mix. But I think it's a viable option because under the breath testing, the technology of breath testing, the window of detection is even shorter. We're talking about 2 to 3 hours. And so if you're looking for recent use detection with a breath test, right now the technology only goes back 2 to 3 hours, but in some ways that's not a bad thing, right? If you're just wanting to identify somebody in the workplace who seems to be under the influence, and you want to identify recent use, that would be a very positive thing if that's your only concern. So that's sort of the answer to that question, Suzanne.
Okay, great. Thanks, Bill. Just a reminder, we will have the copy of the slides available and a recording of the presentation. I see some questions about that. That will be available after the fact. It looks like we have a question. This is for a private sector employer. Is there a defined limit for under the influence of alcohol by state for private sector employers?
Well, so we know we have 0.08 BAC, blood alcohol content level, as sort of a national level for every state. You can have a more restrictive level like Utah has, but it has to be at least 0.08. Now, for DOT alcohol testing purposes, I know our people on the line are thinking that's not the DOT standard 0.08. It's not, right? At 0.02 BAC, you've got to remove an individual from performing safety sensitive functions, right, under the Federal Motor Carrier Safety Administration guidelines. At 0.04, they violated the regulations, and there are certain consequences that kick into place. We won't go into all of that. But if you're putting together your own private sector policy, you may not want to go with 0.08, right? That may be a little bit too high, even though it's the standard, the federal standard for driving. You may want to mirror the DOT regulations with a 0.04 or something, 0.02, we remove them from performing safety sensitive functions, and 0.04 we would consider to be a policy violation with certain consequences kicking in at that point. I see that a lot with workplace policies that we write, where for alcohol testing, they want their program or their policy to reflect the DOT regulations.
Okay, great. Another question, would you test someone for drug use based on just the smell of marijuana, even if in a state that has legalized medical marijuana?
Well, that's a good question. If I was going to do that, I would want to make sure that there were other things prompting the drug test, triggering the drug test. But If somebody comes into the workplace, say back from their lunch break, and they have alcohol on their breath, that could trigger an alcohol screen. And so in that same regard, somebody coming back smelling of marijuana, well, that could trigger a, say, reasonable suspicion or for cause tests for, whatever your panel is, that would include THC. But before I could take employment action against that individual, some type of adverse employment action, I'd want to make sure that I'm basing it on more than just the drug test result. If I'm, say, in Illinois, or if I'm in Nevada, or certainly New York City, which has very restrictive laws on pre-employment testing and THC. They don't even allow it, or they won't allow it come May of this year. So it depends on the state that you're in, but I'd want to make sure my policy states these things very clearly so that no employee could come back and say, well, I didn't know. It's in the policy, and we have documentation showing that we informed you of the policy.
Okay, Bill, that leads into what you mentioned, just leads into another question. What's the latest on drug testing for New York City?
Well, as I mentioned, New York City passed a law. I consider it really to be one of the most restrictive laws when it comes to drug testing. In May this year, when this city ordinance really goes into effect, it will prohibit drug testing, pre-employment drug testing, and you won't be able to test individuals for THC on a pre-employment drug test. It would be considered, quote unquote, and this is directly from the city ordinance, an unlawful discriminatory practice. However, this is very interesting, and you see this in other places. It includes what are becoming known as safety sensitive carve-outs. In other words, the law applies to everybody except people in certain safety sensitive occupations. So in New York, for example, police officers, emergency responders, safety sensitive positions like drivers, etc., any job requiring a security clearance, people who supervise the care of children or medical patients or other vulnerable persons, they would be exempt from the prohibition on pre-employment drug testing. Isn't that interesting, right? We're going to prohibit pre-employment drug testing, but we recognize that drugs are bad and people under the influence of drugs maybe have problems in performing their jobs. So for these certain occupations, the law will not apply. I think that's telling evidence that in reality, it's not a good law, period. The fact that they're exempting safety sensitive workers for it, and then limiting what the definition of what a safety sensitive worker is to what the city's decided. There are a lot of occupations that maybe don't fall under this list that they have that would also pose a danger to the public or to the people in your workplace to have individuals doing those jobs, which are excluded from this list, under the influence of marijuana, for example.
Okay, and then maybe just a continuation, if you don't mind me asking a question on a question, Bill. How does that apply then post-employment? So you mentioned pre-employment in New York City, how that's being limited, but what about post-employment drug testing or ongoing drug testing for employees?
Yeah, that's a perfect question. So right now, the sort of the movement in some of these very restrictive states like Nevada, for example, is to, and forgive me, my bias is coming out here, but obviously I'm someone who favors drug testing. It's to attack pre-employment drug testing, to prevent an employer from, quote unquote, discriminating against somebody who's a legal user of marijuana. That attitude, that push is starting to spill over into post-hire drug testing as well. Not widespread yet, but protecting the rights of that individual who's a legal user of marijuana from being discriminated against. In the same sense that an employer in almost every state right now faces discrimination laws that prevent you from discriminating against smokers, for example, or against alcohol users, not abusers or alcoholics, but users. And so many states have laws that prohibit employers from discriminating against individuals who do legal things. And in many states now, marijuana is legal as well. So you're starting to see that creep into the post-hiring or its effect on post-hiring drug testing. But right now, there's no state that would prohibit you from testing, say post-accident or reasonable suspicion, have always been states that have had restrictions, not prohibitions, but restrictions on random drug testing. Although there are a couple that make it so hard that you really can't do random testing in those states. But right now, you can do employee drug testing in every state. You just need to check with the law in all the states where you have business operations to make sure that your post-hire testing complies with those state laws.
Okay. I know we're a bit over our time, Bill. Do you have time for just a couple more questions?
Yep, keep going.
Okay, we've got some really good ones here. This one says, what testing rates do you suggest for non-DOT safety sensitive employees as opposed to non-safety employees?
So I assume we're talking about random frequency rates.
I believe so, yep.
Yeah, so we know that the Federal Motor Carrier Safety Administration has re-upped to the 50% level, right? And those random rates are based on the positivity rates from the previous year. So if it drops below a certain percentage, then DOT or a mode, like in this case Federal Motor Carrier, would drop the random frequency rate, and if it goes above a certain level, they'll increase the random frequency rate, and that has a direct impact on the cost of maintaining a drug testing program. But outside of the federal regulations, so under the DOT regulations, for example, those answers to the questions are dictated to you. You have to do it at a certain level, depending on if you're covered by Federal Motor Carrier, Federal Railroad, Aviation, etc. Outside of the DOT regulations, you want to, one, check with your state law to make sure that you're complying with the state law. Very few states really delve into things like frequency rates. But as I said earlier, many states defer to the federal guidelines. That doesn't necessarily mean that you've got to test half of your workers or 50%. I'm saying that wrong, and that's misleading. Let me clarify that you're using a 50% random frequency rate. It doesn't mean that you're testing half of your workers, 50% of your workers. It means that whatever half of your workers, whatever that number is, let's say you have 100 employees, and it's a 50% rate that you're applying, then you're looking at conducting at least 50 random drug tests in the year. It could be a different person each time. That's the nature of random testing. But to be more specific, the US Navy, and this goes back 30 years, maybe 25, 30 years, they did a study and they determined that the optimum random testing rate is at least 20%. That, in other words, you don't want to go below 20%. There may be a point of diminishing returns above 20%. They didn't say that, but maybe that's why they came to that conclusion. But they determined that the optimum random frequency rate is 20%. I don't necessarily agree with that nowadays because drug abuse has increased so dramatically over the last 8 years since the legalization of marijuana in several states. And if you look at some of the major labs, there's one major laboratory that puts out a report every year, and they're showing a significant increase in marijuana positives over the last 3 to 4 years. And so we're seeing more drug abuse in the workplace. Random testing is a way to deter drug use. It keeps people honest, so to speak. So 20% minimum, somewhere a little bit above that, 25, 30%, probably still not a bad idea. But the deterrent effect of random testing is only as good as your education program. Making sure that your employees understand, we conduct random testing, this is how we do it, this is what the frequency rate is, you can be selected more than one time, and that sort of keeps people honest. I think random testing is a very valuable, important tool available to employers. But again, make sure you're complying with the state laws that apply to you, because some states do apply some restrictions to random testing. They don't prohibit it necessarily, but they have conditions in place that you have to comply with.
Okay, looks like we have maybe time for just 2 more questions, if that works for you, Bill.
Sure.
And then if questions are not answered, we'll be sure to follow up. But this question is, given that the use of marijuana has a 24-hour impairment on the user, how does the law allow for interaction between the user for leisure or medical use and them doing their job? It looks like this is in relation to caregiving or healthcare, I believe.
Yeah, and that's such a good question, especially in that industry, but other safety sensitive industries as well, where you're taking care of people or you're operating heavy machinery, etc. Because even though, as I talked about earlier, with oral fluid testing, you're detecting recent use, somebody can still be considered under the influence, 8 hours later, 12 hours later, even up to 24 hours later. It doesn't, they're still going to have drugs in their system, and they could still test positive beyond 24 hours, especially with urine testing. But it shows that there's an impairment effect on that individual for that period of time up to 24 hours. But again, I'm not going to focus on impairment in my company policy. I'm going to focus on under the influence. And I'm not going to create a burden that I can't meet by trying to prove that this drug test result says the individual's impaired. I'm going to stick to under the influence because that's indisputable. The individual has drugs in their system, and that's proven by the positive drug test result. But for this individual who asked the question, who's coming from that industry, so very, very important that you, and this becomes a selling point for your services in that industry if you're a service provider, which is that our company conducts drug testing, and we test for these drugs under these circumstances, and any individual in our company understands that they're possibly going to be subject to drug testing if they're at work under the influence of drugs, if they're exhibiting the signs and symptoms of somebody who may be under the influence of drugs while at work. But it's got to be in your policy. Your supervisors have to understand their role, and your employees have to be educated to know what the company's expectations are for job performance, and how sometimes a drop in job performance or exhibiting the signs, the outward signs of and symptoms of substance abuse can trigger a drug test.
Okay, and then final one, Bill, what is the best resource to find accurate drug testing laws?
Well, you know what, Suzanne, I'm going to have to say that the best source is our company, the Current Consulting Group. And that's a bit of a loaded question. Should have asked that at the beginning where we had still everybody on the line, right? But we do have a website, currentcompliance.org. It's a massive database of all laws at the state level that affect drug testing. So it's not just drug testing laws, but it's unemployment laws, workers' comp laws, marijuana laws, and even case law. So that on a state-by-state basis, you can find all the information that you need on laws that could affect your drug testing program. You can search the database by word, by phrases. If I wanted to know every state that allows instant oral fluid testing but prohibits random testing, I can search it that way. It's really the only online database of state drug testing laws or laws that affect drug testing in the state that really exists in the industry. We've got hundreds and hundreds of subscribers. It's a real good source of information. Beyond that, though, there are other ways to find this information. I mean, 30 years ago, when I wrote a book called State Drug Testing Laws and Legislation, and we didn't really have the internet like we have today, we would call states, we would call state governments and request the information that way. Nowadays, of course, you can do searches on the internet and piece it together state by state. It's a little bit more complicated, but as somebody who did it myself that way for 25, 30 years ago, it can be done. Or you can just go to one single source where all the information's available at your fingertips.
Okay, well, perfect. Well, thank you so much for staying on and answering the really great questions that our audience had. Thank you for your time. Thank you for all of this information. We'll be sending along the slides and the recording of the webinar to everyone. We'll make that available shortly. And then just a note that our next webinar will be on March 26th, same time, noon Central Time, and will be given by Scott Paler. He will be giving a legal perspective on employer considerations regarding legislation for background screening and drug testing. So stay tuned for that in a little less than a month. So thank you everyone for your attention and your time today. And Bill, thank you again.